As House members of both parties are expressing concern over the scope of the federal government's surveillance and data collection programs, revealed by former NSA contractor Edward Snowden. In this portion of a recent House Judiciary Committee hearing, members heard from civil liberty advocates, as well as a former member of the George W. Bush administration. This is an hour and 20 minutes.
Panel, and ask that each of you rise and be sworn in. Do you and each of you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Let the record reflect that all the witnesses responded in the affirmative, and we'll now introduce our witnesses. Our first witness is Mr. Stuart Baker, a partner at Steptoe & Johnson law firm here in Washington, D.C., and we'd ask that the door in the back be closed so we can have a little more. Mr. Stuart Baker is a partner at Steptoe & Johnson here in Washington, D.C. Mr. Baker also serves as a distinguished visiting fellow at the Center for Strategic and International Studies. Previously, he served as the first Assistant Secretary for Policy at the U.S. Department of Homeland Security. He also served as General Counsel of the NSA, where he led NSA and interagency efforts to reform commercial encryption and computer security law and policy. Mr. Baker has been a visiting fellow at the Hoover Institution and a fellow of the university's Center for National Security Law. Mr. Baker received his bachelor's degree from Brown University and his J.D. from the UCLA School of Law, where he was chief articles editor of the UCLA Law Review, and we are very fortunate to have him and his expertise with us today. Our second witness is Mr. Jamil Jaffer, Deputy Legal Director of the American Civil Liberties Union, and also serves as Director of the group Center for Democracy. Mr. Jaffer previously directed the ACLU's National Security Project. Prior to joining the ACLU, Mr. Jaffer clerked for Amalia Kierce, the U.S. Circuit Court of Appeals for the Second Circuit, and the Right Honorable Beverly McClatchin, Chief Justice of Canada. Mr. Jaffer earned degrees from Williams College, Cambridge University, and Harvard Law School, and we welcome his expertise and experience as well. Our third witness today is Mr. Stephen G. Bradbury, an attorney at Deckert LLP here in Washington, D.C. Formerly, Mr. Bradbury headed the Office of Legal Counsel in the U.S. Department of Justice during the administration of George W. handling legal issues relating to the FISA court and the authorities of the National Security Agency. He served as a law clerk for Justice Clarence Thomas on the Supreme Court of the United States and for Judge James L. Buckley of the United States Court of Appeals for the D.C. Circuit. Mr. Bradbury is an alumnus of Stanford University and graduated magna cum laude from Michigan Law School. We thank him for serving as a witness today and look forward to his insight into this complex topic. Our final witness on the first panel is Ms. Kate Martin, Director of the Center for National Security Studies since 1992. She was formerly a lecturer at Georgetown University Law School and has also worked in the position of General Counsel to the National Security Archive. She is currently a member of the Constitution Project's Bipartisan Liberty and Security Committee. Previously, Ms. Martin was a partner with the Washington, D.C. law firm of Nussbaum, Owen, and Webster. She graduated from the University of Virginia Law School, where she was a member of the Law Review, and from Pomona College with a B.A. in philosophy. We welcome her dedication and expertise in this area. Thank you all for joining us, and we'll begin with Mr. Baker. Each witness should summarize his or her testimony in 5 minutes or less. Your entire statement will be made a part of the record, and to help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired. Mr. Baker, welcome. You may want to pull the microphone close and turn it on.
Member Converse, yes, thank you very much. It's a pleasure to be here, and I will say that this is not as an unprecedented climate as it may seem. I thought I'd take advantage of the fact that it's my birthday to talk a little about the history of FISA. Here's a quote from the Cato Institute. If constitutional report cards were handed out to presidents, the president would receive an F, an appalling grade for any president, let alone a former professor of constitutional law. About the same time that they were saying that the FISA court judge, chief judge, felt obliged to say, we are not a rubber stamp. I carefully review every one of these applications. This was the second term of Bill Clinton, when many of these criticisms were very prominent, and quite frankly, I think they contributed to the FISA court at the time adopting, it turned out without legal justification, a set of restrictions on the conduct of intelligence that built a wall between law enforcement and intelligence that contributed directly to the FBI not being able to find the hijackers when they knew they were in the country but were not allowed to look for them because they were on the wrong side of the wall. I say that because this climate and the search for ever greater protections for civil liberties does have a cost, and we don't know where that cost will be paid. That's why it seems to me that we need to be as careful as we can to ask the question, what sorts of protections are there really? And I will confess, I was very surprised and a little troubled when I saw that initial metadata order. Only when I came to realize that the order allowed the collection but not the actual searching of that data, and that the searches were so carefully circumscribed that only 300 were made in a particular year, that I realized that when you look at the two sets of orders together, that there is actually extraordinary limitations on the ability of anyone at NSA to look at metadata of any individual. I contrast that to the fact that there are hundreds of thousands of subpoenas issued every year for metadata by state and local law enforcement with far fewer guarantees of protection for that data. And then finally, and I'll close with this, the other cost that we are likely to pay here is that we are not the only audience for the debates that we are going through. It may feel like a family fight, but the neighbors are listening. And indeed, Europe has already made it clear that they intend to punish everybody who participated in these programs if they possibly can. They intend to try to restrict our intelligence gathering by going after the companies that only did their duty in responding to orders that were lawful under U.S. law. This is a fixed feature now of European public policy and diplomacy. It ignores the fact that, by and large, the U.S. record on protecting civil liberties and even this kind of data is much better. According to the Max Planck Institute, you're 100 times more likely to be surveilled by your own government if you live in the Netherlands or you live in Italy. You're 30 to 50 times more likely to be surveilled if you're a French or a German national than in the United States. Only in the United States and Japan are there limitations on simply volunteering information to government if you happen to have this metadata. As long as you have a good reason, by and large, you can give it over, and certainly law enforcement would appear to be a good reason. And on this question of assembling a database of metadata, the Europeans don't do that because they passed a law telling every one of their carriers, you assemble the database, you maintain it, and if law enforcement comes calling or if you want to volunteer the information, you'll have it. We've never done that. We've never had a data retention law in the United States for civil liberties reasons, and that's one of the reasons why we have ended up trying to collect this data and then imposing a set of limitations on when it is searched. I will reserve and answer any questions you may have at the end of the discussion.
Thank you, Mr. Baker. Mr. Jaffer, welcome.
Thank you. Mr. Chairman, Mr. Ranking Member, members of the committee, on behalf of the ACLU, thanks for the invitation to testify today. Over the last 6 weeks, it's become clear that the NSA is engaged in far-reaching, intrusive, and unconstitutional surveillance of Americans' communications. Under Section 215, the NSA is tracking every single phone call made by a resident of the United States, who they called, when they called them, for how long they spoke. Until recently, it was tracking ordinary Americans' Internet activity as well. Under Section 702, and on the pretext of monitoring people outside the United States, the NSA is using Section 702 of FISA to build massive databases of Americans' domestic and international communications, not just so-called metadata, but content as well. Those programs have been made possible by huge advances in the technology of surveillance, but in many respects they resemble the generalized warrants, the generalized surveillance programs that led to the adoption of the Fourth Amendment more than 200 years ago. The FISA court orders resemble general warrants, albeit general warrants for the digital age. That the NSA is engaged in this kind of unconstitutional surveillance is the result of defects in the statute itself and in the current oversight system. FISA affords the government sweeping power to monitor the communications of innocent people. Excessive secrecy has made congressional oversight difficult and public oversight impossible. Intelligence officials have repeatedly misled the public, Congress, and the courts about the nature and the scope of the government's surveillance activities, and structural features of the Foreign Intelligence Surveillance Court have prevented that court from serving as an effective guardian of constitutional rights. To say that the NSA's activities present a grave danger to American democracy is not an overstatement. 36 years ago, after conducting a comprehensive investigation into the intelligence abuses of the previous decades, the Church Committee warned that inadequate regulations on government surveillance, quote, threaten to undermine our democratic society and fundamentally alter its nature. That warning should have even more resonance today than it did in 1976. Because in recent decades, the NSA's resources have grown, statutory and constitutional limitations have been steadily eroded, and the technology of surveillance has become exponentially more powerful and more intrusive. Because the problem that Congress confronts today has many roots, there is no single solution to it. But there are a number of things that Congress should do right away. It should amend Section 215 and 702 to expressly prohibit suspicionless or dragnet monitoring or tracking of Americans' communications. It should require the executive to release basic information about the government's use of foreign intelligence surveillance authorities, including those relating to pen registers and national security letters. The executive should be required to disclose for each year how many times each of those provisions was used, how many individuals' privacy was implicated by the government's use of each provision. And with respect to any dragnet, generalized, or bulk surveillance program, it should be required to disclose the types of information that were collected. Are they collecting medical records? Are they collecting educational records? Are they collecting firearms records? That should be disclosed to the American public. Congress should also require the publication of FISA court opinions that evaluate the meaning, scope, or constitutionality of the foreign intelligence laws. The ACLU recently filed a motion before the FISA court arguing that the publication of those opinions is required by the First Amendment, but Congress need not wait for the FISA court to act. Congress has the authority and the obligation to ensure that Americans are not governed by a system of secret law. Finally, Congress and this committee in particular should hold additional hearings to consider further amendments to FISA, including amendments to make FISA court proceedings more transparent. Congress should not be indifferent to the government's accumulation of vast quantities of sensitive information about Americans' lives. This committee in particular has a crucial role to play in ensuring that the government's efforts to protect the country don't compromise the freedoms that make the country worth protecting. Thank you.
Thank you, Mr. Jaffer. Mr. Bradbury, welcome.
Thank you, Mr. Chairman, Ranking Member Conyers, and distinguished members of the committee. I believe both of the recently disclosed NSA programs are critical to our national security, and I have every confidence that each is authorized by statute, consistent with the Constitution, and appropriately protective of privacy and civil liberties. The first program involves the acquisition of telephone metadata under a Section 215 business records order. This metadata consists only of tables of numbers indicating which phone numbers called which numbers and the time and duration of the calls. It doesn't reveal any other subscriber information, and it doesn't enable the government to listen to anyone's phone calls. There's no monitoring or tracking of phone calls. The Constitution does not require a warrant supported by probable cause to acquire this metadata. Courts have held that there isn't a reasonable expectation of privacy in the phone numbers that are dialed, and the production of business records like these doesn't involve a Fourth Amendment search. This acquisition is authorized under the terms of Section 215 because the use of the metadata is relevant to counterterrorism investigations. Acquiring a comprehensive database enables better analysis of the telephone links and calling patterns of terrorist suspects, which is often the only way to discover new phone numbers being used by terrorists. To connect the dots effectively requires the broadest set of telephone metadata. The same relevant standard applies in other contexts, such as administrative subpoenas and grand jury subpoenas, which, unlike Section 215, typically do not require court approval. While the metadata order is extraordinary in the amount of data acquired, it's also extraordinarily narrow and focused because of the strict limitations placed on accessing the data. There's no data mining or trolling through the database looking for suspicious patterns. By court order, the data can only be accessed when the government has reasonable suspicion that a particular phone number is associated with a foreign terrorist organization, and then that number is tested against the database to discover its connections. If it appears to be a U.S. number, the necessary suspicion can't be based solely on First Amendment protected activity. Because of this limited focus, only a tiny fraction of the total data has ever been reviewed by analysts. The database is kept segregated and is not accessed for any other purpose, and FISA requires the government to follow procedures overseen by the court to minimize any unnecessary dissemination of U.S. numbers. Any data records older than 5 years are continually deleted from the system. The order must be reviewed and reapproved every 90 days, and my understanding is that since 2006, 14 different federal judges have approved this metadata order. Let me now turn to the surveillance program that targets foreign communications. This program is authorized under Section 702 of FISA, and if we just track through the provisions of Section 702, we can see the outline of this program. With court approval, Section 702 authorizes a program of foreign-focused surveillance for periods of 1 year at a time. This authority may only be used if the surveillance does not, 1, intentionally target any person of any nationality known to be located in the United States, 2, target a person outside the U.S. if the purpose is to reverse target any particular person believed to be in the U.S., 3, intentionally target a U.S. person anywhere in the world, and 4, intentionally acquire any communication as to which the sender and all recipients are known to be in the U.S. Section 702 mandates court approval of the targeting protocols and of minimization procedures to ensure that any information about U.S. persons that may be captured in this surveillance will not be retained or disseminated except as necessary for foreign intelligence purposes. From everything that's been disclosed about this program, including the so-called PRISM Internet collection, I don't think there's any reason to doubt that this foreign-targeted surveillance is just what Section 702 was designed to authorize. Thank you, Mr. Chairman.
Thank you, Mr. Bradbury. Ms. Martin, welcome.
Thank you, Mr. Chairman. And Ranking Member Conyers and other distinguished members of this committee for inviting me to testify today. I want to first of all thank the committee for having asked some questions of the government witnesses that I hoped the committee would ask, and congratulate you upon obtaining answers, at least in part, to some of those questions. I want to raise two overarching concerns today about these programs, and note, first of all, that I think it does not make sense for the committee to consider the 215 program and the 702 program separately, and instead that they need to be looked upon as part of an overall set of foreign surveillance authorities that work together to allow the government to collect and keep massive amounts of information about Americans, and to do so in secret, and that's the real nut of the problem. We have an incredibly complex set of laws governing those authorities and setting up safeguards, as this committee is well aware. And we need to understand how those work together, where the holes are, and where the potential changes are. So I would urge the committee in going forward to expand your oversight and your questions to look at not just 215 and 702, but the entire FISA program, FISA authorities, and not just as exercised by the National Security Agency, but equally significantly with regard to how the information is shared between the NSA, the FBI, the DHS, and perhaps the White House or the NCTC as well. That those are equally critical questions for both civil liberties and for evaluating the effectiveness and the necessity of the programs. I think that I would agree with Mr. Jaffer and many of the members here today that there's a lot to be concerned about, that we are seeing the unprecedented massive collection of information on Americans, the creation of secret data banks which are available for government analysis, queries, and data mining by ever increasingly sophisticated computerized tools, and the dissemination of both raw information and the results of such analysis or data mining throughout the executive branch. I think that the question is whether or not these new activities by the government have the potential to fundamentally change the relationship between citizens and the state. I think that was the concern that many members of this committee were raising today. And in connection with the question of what is the harm here, I very much appreciate that the administration and the NSA has been very detailed about the internal safeguards that they have created to ensure that no rogue employee or contractor can access the personal information of an individual American and misuse it. I do not believe, however, that that is the primary worry of the American people about these programs. I think rather the primary worry and the primary concern when FISA was first drafted was that the government would succumb to the temptation to use information that it has about individual Americans to chill political dissent, to challenge its political opponents, etc. I think this is one of those instances where when you discuss it in advance, you can never believe that this would actually happen. But that when you look at history, it's happened too many times already in my own lifetime. Just a couple of specific comments about information which I believe would be crucial for this committee's consideration. First, on questions about what does the kinds of authorities does the government have under Section 215. One of the members asked about the collection of Internet metadata. I would urge you to find out specifically whether or not, under the government's current understanding of its legal authorities under 215, it could make an application for the collection of all Internet metadata on communications within the United States, whether or not it could make an application under 215 for bulk collection of geolocation data or bulk collection of financial records or credit card records. I think it's important to know when the government makes one of these 300 queries to the 215 database, is that require the database to do a chained analysis, not simply what numbers have been in contact with the first number, but to then do a chain-linked analysis. I know my time is up, and if I might just make one last comment. On the overall question of this is foreign intelligence, and it traditionally is in secret. It's always done by governments, and it has a high cost when it's discussed in public. It's foreign intelligence when it's directed against foreigners and other governments overseas. We're talking about massive authorities for massive collections on Americans. And that may be foreign intelligence. It's also at the core of the concerns of the constitutional framers. I think that what we've seen about the costs of secrecy here is that...
Sorry. We'll have more opportunities
Okay.
to speak in just a moment. But we'll begin with the questioning, and I'll start with Mr. Jaffer. If the acquisition of metadata is the type of mosaic of information that Sotomayor warned about in the Jones case, how would you limit the government from collecting it?
Well, one possibility would be to require the government to get an individualized warrant for that information. But whatever the answer to that question is, I think that there have to be more safeguards than are in place right now. Even the government seems to concede that its surveillance of this kind of information has to be reasonable under the Fourth Amendment. And I just don't see how you can possibly justify the collection of everybody's phone records on that standard. And I think many members rightly pointed out that no other court has ever granted a subpoena, has ever upheld a subpoena that sought records on that scale.
That's with regard to 215. One objection you have to 702 information collected is that information about Americans can be swept up in the search for foreign intelligence information. But isn't that the case with any Title III wiretap?
It is the case, and that's why the courts apply a reasonableness analysis. And all we've argued in the context of challenges to 702 is that the same reasonableness analysis has to be applied to the government surveillance under that provision. And the government in our constitutional challenge of 702 actually conceded that point. The only dispute was whether these procedures were in fact reasonable, and we don't think they are.
If the FBI is conducting a wiretap of a business that's also part of a criminal conspiracy, innocent third parties sometimes are involved, and they're monitored. That information is minimized to protect the people's privacy. How is this different from Section 702 surveillance, which must be also minimized?
Right. I think that's a good question. I think that one of our concerns is that the word minimization is being used as a kind of talisman, as if when the government invokes the prospect of minimization, that should end the discussion. But you have to look at what the government means when it says minimization. And fortunately, we now have the government's minimization procedures under 702. They were released by The Guardian and by The Washington Post, and they allow us to evaluate the extent to which those procedures actually protect Americans' privacy. And I think it's quite clear from the procedures that they don't protect Americans' privacy. They allow the government to sweep up Americans' communications, both domestic and international, to retain those communications forever to the extent that they include foreign intelligence information, a term that's defined very broadly under the statute. Even if the communications don't contain foreign intelligence information, they can be retained for as long as 5 years. So these are procedures that don't do very much to protect Americans' privacy.
Let me turn to Mr. Baker, Mr. Bradbury, and ask them if they want to comment on Mr. Jaffer's observation and tell us why it is necessary to collect a broad set of metadata under Section 215. Does this help the government connect the dots?
Yeah, the difficulty the government faced is that each telecommunications company keeps its records as it chooses, and they may maintain the records for a year or two, but they won't keep it for a long time, and you can't easily chain from one database to the next to find out the communications of the people who are linked to the person that you are investigating. And to ask the companies to keep it for the government's convenience, to consolidate the database for the government's convenience, is something that is really asking quite a bit of a private citizen just to help the government do its job. So the government did this and then acted.
But let me interject that depending upon the cost of the government taking it and gathering it and holding it, we're asking all those phone companies' customers who are also taxpayers of the United States to bear that burden. So I understand the problem with asking the phone companies to do it, but we also have to evaluate whether the benefits derived from this are justified by the costs of it.
That's a perfectly fair point, although with, the ratepayers and the customers of the phone companies will pay for it in the end if it's a cost of the companies. But I agree with you that it is a cost to the United States. I think it's a cost that we bear because we are trying to protect all Americans from terrorism, and that's fair for the U.S. government to bear that cost. In the end, though, the searches can't be done without a reasonable and articulable suspicion, which in practice has turned out to be much tougher than the standard for serving a subpoena on an individual telephone company. As I said, there are hundreds of thousands, perhaps 1 million such subpoenas.
I understand. Well, that also leaves aside the question whether the Congress intended to give the NSA the authority to gather the data in the fashion they did under the business records provision. But let me ask Mr. Bradbury another question, and he can comment on this as well if he'd like. Mr. Jaffer's testimony claims the government is tracking all American phone calls under the 215 program. Is this what is happening?
No. As I indicated, they're not tracking calls, they're not monitoring calls. The data sits in a database and is only accessed when there's a suspicious number and you want to find the links and connections that that number has to other numbers. But you need to have the whole database. And getting the whole database is relevant to the counterterrorism investigation because you cannot do the kind of sophisticated link analysis that the NSA does without having a comprehensive set of data. It doesn't have to be every single call record, but it has to be the largest collection you can get in order to effectively find all of those connections. And that's because of the technical way they do it, but it's a super valuable tool, and getting the database is relevant. It would be the same if we had suspicion that a terrorist had come into the country, but we didn't know exactly on what flight or where, and you could use 215 to get the flight manifests of all flights in and out of the country during a period of time. And you could put it in a database, and you could query the person's name to find out when he came in. It's irrelevant.
You raised a good analogy, but my debate professor said analogy was the weakest form of argument. So are you suggesting that it would be appropriate if the airlines did not keep that data for a sufficient period of time, that it would be appropriate for the government to tell all the airlines to provide them with all of the flight records of all American citizens so they could hold it in a database and check it when they needed to?
Well, it might be. It might be something that you have to do to find that that particular flight that you need to protect.
Well, I wouldn't argue that there might be occasions when that information would be useful, but it has to be weighed against both the cost of storing the data, and that's just not, computer capability, but also people to manage that, and the risks that are entailed by those people abusing that system if that indeed occurs. Let me turn to Ms. Martin, however, and your testimony includes a number of suggestions for increasing the visibility into the increasing visibility into the FISA programs. Which of these would you prioritize as a way to both preserve our national security efforts while also giving the public a better understanding of how the programs work?
I think that it's key to obtain an understanding of the court's understanding of its legal authorities, not just on 215, but on all of the, and on the government's interpretation and understanding of those legal authorities. I think it's also key, though, and the second thing that I would prioritize is getting a report from the government of how the existing FISA authorities complement, overlap, and differ. And and what they allow and what they don't allow, because I think otherwise we're going to be in the situation where we're talking about fixing 215 with regard to phone metadata without knowing how the government's going to use national security letters or pen traps or 702 to get the same kind of data. So I'd basically prioritize knowing the law and understanding how that works and the government's understanding of the legal authorities. And then after that, some idea, not the specifics, of the scope of the collection that's being done on Americans.
Thank you very much. My time has expired. The Chair recognizes the gentleman from Michigan, the ranking member, Conyers, for 5 minutes.
Thank you, Chairman Goodlatte. This has been a very important hearing, and I wanted to begin by asking Professor Martin about a decision by Justice Alito, a 5-4 decision as usual, responding, who dismissed a number of groups for a lack of standing, reasoning that respondents can't manufacture standing by choosing to make expenditures. Is the harm alleged by, among others, Amnesty International and ACLU, hypothetical, which was the basis of this conservative decision?
Well, thank you for that question, Mr. Conyers. If I might answer it, that case, of course, was a challenge to the constitutionality of the 702 collection program. And one of the points that the government made when it argued that the ACLU and Amnesty didn't have the kind of particularized standing or showing of harm that the Constitution required was that others would be able to challenge the constitutionality of 702 collection, and in particular, individuals who were prosecuted using the fruits of such 702 collection. Well, now it turns out that the government won't even tell such people that it used the fruits of 702 collection in making a criminal case against them, and they are not given that opportunity to challenge the 702 collection. I do think that it's an appropriate question for the Congress to worry about as to if you've designed a system that allows the government to collect massive amounts of information about Americans, but in secret, but somehow you haven't set up any mechanism that the Supreme Court's going to recognize as granting standing to anybody to challenge the fact that information about them has been collected. But that's a problem that Congress can solve and should solve. And that's a fundamental difference, of course, between foreign intelligence collection authorities that we're talking about today and the kind of criminal justice collection authorities that were discussed, which is that there is the possibility of an open, adversarial court challenge to criminal collection, which doesn't exist in this context.
Could I ask,
my colleagues are successful.
Can I ask Mr. Jaffer, in addition to your 4 recommendations, is there a way that we can reconcile our concern against terrorism and at the same time permit the largest usefulness of privacy possible? You know, after all, if it hadn't been for a couple people leaking, we wouldn't have known about any of this, as far as I'm concerned. Some say that somebody made a statement on the floor of the House. If you happen to have caught it, you could go back and track it. But I think I'm more concerned about the collection legality than I am about the uses to which it is put.
Well, I think that you ought to be concerned about the collection. The collection in the first instance implicates privacy. It has a real effect on privacy. That's where the privacy intrusion happens in the first instance. And it also has a chilling effect on activity protected under the First Amendment. It's the government's collection of that information that has the chilling effect. If you remember, during the 1960s and 70s, some state governments used subpoenas served on the NAACP as an effort to chill association with the NAACP. And it was just the acquisition of that information that was chilling, and those governments knew it.
And more chilling now than anything is the fact that they've got information through phone numbers, which can easily be attached to names, of everybody in the country for at least 6 years. And that is probably the most disturbing aspect of this matter to me that I've been hearing today.
Mr. Conyers, if I could just point out that even if you accept the government's frame here and focus only on the uses, I don't think anybody should be misled by this 300 number, which makes it sound like this is a very targeted program. But if you think about the 300 number in relation to what was said on the previous panel about 3 hops, the first hop takes you to, say, 100 people whose communications are pulled up. The second one takes you to 10,000. And the third one takes you to 1 million. And you do that 300 times, I think it's safe to say that every American's communications have been pulled up at least once.
Mm-hmm. Thank you very much.
I will recognize myself now. I appreciate your being here. It is intriguing, and what we're talking about the privacy, the type of concerns that spawned the revolution back over 200 years ago. We hear all this information about the FISA courts, and that's the bulk of what you're talking about. Anybody care to just briefly tell us what happened before there was a FISA court? We know there have been national security secrets since the revolution itself. What happened before there was a FISA court to protect us from ourselves?
It was left up to the executive. It was unilateral action by the executive in the area of foreign intelligence surveillance. And in fact...
But here we're talking about surveillance of Americans, in-country American citizens, and that's what I'm talking about. If someone wanted to gather intelligence information about American citizens on American soil, normally, having been a judge and Chief Justice, is my understanding, you went to a court, you might be requesting in-camera review of documents, you might request that the court documents be sealed, but we were able to work pretty well getting court orders before there was ever a FISA court, was my understanding.
Actually, Mr. Chairman, prior to 1972, for any national security investigation, or many, they were done without court approval, without warrants. And the United States Supreme Court in the Keith case in 1972 said when it's a domestic security threat, there has to be a warrant. Left a footnote, was not deciding foreign security threats. Even if it's a U.S. citizen, but associated with a foreign power that is threatening to the United States. And the lower courts consistently held that the President could conduct warrantless surveillance for foreign intelligence purposes, even of U.S. citizens, and that the fruits of that surveillance could later be used in a criminal prosecution, even if it hadn't been supported by a warrant. That's what the lower courts held. Of course, that did lead to abuses because the executive was making determinations about what he thought was a foreign threat, and lines were crossed and abuses occurred. That's why Congress and the executive branch reached a compromise in 1978 and created the FISA process to involve Article III judges in the review and approval of those surveillance orders, and also involve the Congress through the creation of the Special Intelligence Committees for Oversight, which hadn't occurred before. And so we have this compromise situation where the branches have come together to involve all 3 branches. And of course, limitations were discovered after 9/11. A lot of debate occurred, and ultimately Section 702 was passed in 2008 to enable a very broad programmatic order for foreign collection directed at non-U.S. persons outside.
And that's a great distinction, because I know in my freshman term, 05 and 06, what we were told is this is only for, you have to be a foreign agent, a foreign individual, and as long as it's an American citizen here on American soil, with distinction for American citizen, where intelligence gathering in another country didn't violate local law. There were all those distinctions being discussed. But even through all of that, my experience with conservative and liberal judges would have indicated that you wouldn't have an order from a judge under our Constitution that requires specificity as to a place and information to be gathered that would say something like this order from this court does, all called detail records between the United States and abroad, or wholly within the United States, including local telephone calls. I think that pretty much covers everything. I see no specificity here. Oh yeah, just get all the records, and you should be comforted by the fact that, you know, you can get this stuff. It's okay. So I'm just concerned. I've now seen the incredible abuse by the FISA court, in my opinion, and I'm just wondering if we're better off going to a system where we don't require a FISA court. There's not this star chamber. What would be another alternative? And that would be my last question.
If I might, Mr. Gomer. I think that the original conception of the FISA court was quite limited and perhaps quite useful, which was that it would act as a kind of usual court in issuing a warrant, right, which is always done ex parte, but that because the search that the FISA court was going to authorize, which had to be particularized, had to be based on probable cause, was never going to be revealed. They were going to set up secret procedures for doing that. But it was always recognized that what we're talking about is searches and seizures of Americans. And now they've basically taken the concept of a FISA court to kind of, in my view, put a fig leaf on a totally different kind of collection directed at Americans. It's not particularized, it's totally in secret, and that includes the 702 program,
right.
Which,
well,
and so that you need to go back to the drawing board about, are we really going to have unparticularized collection that's intended and does collect information about America?
Well, let me tell you, we've got votes coming up in just a few minutes, and so I want to get to people that want to ask questions. But I would ask the witnesses, if you have any proposals, if you could provide that in writing to us, any alternatives, any major changes, because I think this justifies major changes. And with that, who's next? Okay. Recognize the gentleman from New York, Mr. Nadler.
Thank you. Mr. Jaffer, various administration officials have used comparison of Section 215 authority to what can be obtained through a grand jury subpoena, something we expressly include in the statute itself as a limiting principle. Are you aware of any examples where, by virtue of grand jury subpoena, law enforcement has been able to engage in the type of ongoing bulk collection, what you described as dragnet collection of information done under Section 215?
No, not even close.
Mr. Baker, are you aware of any such?
There are plenty of subpoenas for massively overbroad collections of data so that the government can be comfortable that it has gone through everything that might be relevant.
There are subpoenas, grand jury subpoenas, for, in effect, everything in the world, without being specific, all metadata?
Addressed to a particular case or database. There are plenty of cases where a single database has been subpoenaed.
No, a single database, but has there ever been a grand jury subpoena that says, let's see the outside of every postcard or a letter sent in the United States, or let's see phone numbers of everybody who called anybody in the United States?
So if I could go back to an example that the chairman mentioned, as a practical matter, every flight that comes into the United States, every travel reservation on that flight is provided to the government.
Has there ever been a subpoena for every flight record in the United States?
Every flight record coming into the United States, yes.
A subpoena for every flight record?
No, it's under a law passed by the United States Congress that says you must provide this information to the government so it can search for terrorists.
You must provide the name of every individual on every flight?
Yes. That was passed in 2002
and that's a
has
subpoena.
Been enforced, and it has caught a lot of terrorists.
That was a subpoena?
No,
that's a law.
It was a law.
A law. It's a little different from a subpoena. Okay. Mr. Bradbury, you talk about how the metadata that is acquired and kept under this program can be queried when there's reasonable suspicion, as if that meets the statute. The statute talks about collection. You seem to be talking about query. There's a difference between collection and query. Mr. Jaffer, let me ask you this. Does the Fourth Amendment talk to collection or to queries?
Collection.
Collections. So a broad, okay. Let me go to the next question because I have a bunch quickly. Mr. Jaffer, you talked, Mr. Baker rather, you talked about Section 702 as the discussion of Section 702 has really hurt us because it's told the Europeans and everybody else what we're doing for foreigners. But nothing, as I think you point out in your testimony too, nothing that we have learned about Section 702, I can't think of anything we've learned about Section 702 from Mr. Snowden, or whatever you pronounce his name, that wasn't included in the debate in 2008 on Section 702, when we knew we were going to be collecting across the board on everybody. And the question in that debate was, and I thought the resolution of that debate was inadequate, which is why I voted against it, how we were going to protect Americans against being caught up in this, as we've been talking about. But the assumption there was that foreigners have no constitutional right, we can get and no privacy rights, we can get all the information on them anyway. So how is this information now harmful in a way that the congressional debate wasn't?
I think the congressional debate seeded what we're now seeing. It's a cost. It's a cost of having the debate we're having. And my point here is that Europe will extract that cost from companies that did nothing but their obligation.
But they would have extracted that cost just because of the congressional debate if they were paying attention.
What I would say is that this Congress and this administration has an obligation to stand between those companies and Europeans.
That's a separate discussion, that may be, but okay, Ms. Martin, how can Congress solve the problem? We have a basic problem. Every challenge to abuse of constitutional rights by the Bush administration and the Obama administration has been met in the same way. Either the use of the state secrets doctrine to say you can't go to court on that, the subject matter of the discussion is a state secret, therefore move to dismiss the case ab initio, or you have no standing because you cannot prove that you personally were harmed by this. Now, Mr. Snowden may have done a public service in giving some people standing by proving that they were harmed by this, because anyone who's a Verizon subscriber arguably can now go into court and say that. How can we deal with these two problems, that any administration can violate constitutional rights from here to kingdom come, subject to no court review because of either the state secrets doctrine or the standing problems, because they don't admit what they're doing in the first place. It's secret. It's secret what we're doing to you, therefore you have no standing because you can't prove what we're doing to you.
Time's expired, but you may answer briefly.
Well, I think one key way of doing it, which is outside the court system, is for the Congress to insist that the administration disclose all that information. It then won't be able to claim state secrets because it's disclosed the information.
Disclose what information?
Right. Disclose the information about what it's done and who it's done it to, right? And something like that did happen and is happening in the context of the violations of the laws against torture. And that it helps then in having a consensus that we know the government violated the law, we have some kind of public debate about what the government shouldn't do, and whether or not we end up with an individual remedy in the court, I think is a question that I would be glad to think about some more. I know there are now 5 lawsuits seeking individual remedies that have a better chance than they did before. They but they all depend upon public disclosure by the administration of information.
Or by Mr. Snowden or somebody else.
Well, that's more difficult because then the administration claims state secrets.
We're going to have to, in order to get the other 2 Democrats and 1 Republican left, we're going to need to move on. But I would ask, if you have additional information, if you provide that in writing in response to that question. And this time we yield 5 minutes to the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. Mr. Jaffer, I'm trying to figure out how we got from Smith versus Maryland to the moment that we're at today. Can you try to explain to me what exactly maybe the proponents of these laws and the interpretation of these laws are trying to say, because I'm not following Smith versus Maryland very well. I've read it a couple of times, and I'm not sure that you can get to the collection of metadata all over the United States.
Well, I think that there is a vast chasm between Smith and the kind of surveillance that's going on now. Smith was a case about a specific criminal investigation. It was a pen register installed on one person's phone for 2 days. We are now talking about 7 years of surveillance of every American's phone call. So I don't think that it's a serious argument to say that Smith justifies what the government is doing now. I think that the more relevant case is Jones, which was decided just last year. A 9-0 court found that the tracking of individuals' location over the long term constituted a search under the Fourth Amendment, and you know, even in Jones, the surveillance was narrower and shallower than the kind of surveillance we're talking about today.
And they said that the tracking of individuals over a long period of time resulted in a search and seizure. Can you explain why they said that? Because there's now an argument that collecting all this data actually gives you very personal information about the individual.
That's right. You know, sometimes we talk about metadata as if it's less sensitive, and that's not really true. Using this kind of metadata in Jones, for example, the court noted that you could, just tracking somebody's location over a long period of time, you could draw all sorts of accurate conclusions about their medical history, about their intimate relationships, about their professional life, about their personal life. And the same is true of phone calls. If the government has access to your call records over a long period of time, the government can draw all those conclusions in the same way. Now, that's not to say that the government should never have access to the phone records. There are circumstances in which the government has to have that access, but we just want to make sure that that is limited to cases, specific cases, in which the call records are in fact relevant to an
and in Smith versus Maryland, there was a specific reason why it was relevant.
That's
correct?
Right. Even in Jones, there was that specificity.
Okay. So, because what concerns me is that, you know, I think as a government official, as a legislator, I'd like to stop gang membership, for example, or I'd like to stop child pornography, or I'd like to stop bank robberies, and I could, you know, maybe pass a law that would require the government to collect everybody's data. Right, everybody's metadata, so we can stop those crimes. What do you think about that, Ms. Martin?
I think that's the proven solution of countries like the Soviet Union and China.
Mm-hmm. Exactly.
I mean, and I think there's actually been a study showing that you can stop crime by that kind of, you know, government surveillance and collection.
So, Mr. Baker, what's the difference? You know, I want to stop all these crimes, and I would think that everybody in this Congress would think that that would be inappropriate for me to pass a law that would allow me to collect all the metadata of every American so I could stop child pornography. What's the difference between that and what's happening here in this instance?
We are responding in the case of the 215 programs to the fact that there is a well-organized offshore conspiracy seeking to carry out the tax audits.
And I agree with that, and that's why maybe I don't have as much problem with the 702 program. But you're collecting the data, or the government's collecting the data of American citizens and saying that it may become relevant after we collect it. Why not just collect the data of every every American because it might become relevant in a child pornography case later?
All of these searches, there's really two issues here. First, is it a search at all? And Smith suggests it isn't. And if it is a search, is it reasonable? And that depends in part on the nature of the justification and the problem that you're trying to solve. In this case, we're trying to solve a problem that requires classified tools and is a national security threat. That's different from trying to stop bank robberies, frankly.
Well, and I just find it fascinating that the author of the Patriot Act and most of the members of Congress who voted for the Patriot Act had no idea that the government would go to these lengths to collect data. And I hope that we can continue to have these hearings. Thank you very much for being here.
The time has expired. Thank you very much.
Yield back my time.
Now, yield to the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. I know we're trying to get 3 members in this very short period of time. So let me just pose a question for Mr. Jaffer real quick. I'm interested in what you can do with the data after you've gotten it. There's a real question as to whether you have the legal authority to get all the phone calls. But after you've got it, we found out in the DNA case that if you get someone's DNA legally and you find out it's not them, you can still run that DNA through the database without any probable cause, no articulable suspicion, anything. You have the data and you can use it. What is the limitation on the data after you have acquired it? Now, they say you have to have articulable suspicion to query the data that you have obtained, but the Section 215 doesn't require any such limitation. It just tells you to describe what you're getting. This seems to be a little gratuitous policy, not a limitation by statute. And so can you say a word about where the limitation is after you've gotten the data, what you can do with it?
Well, on the 215 program, we don't have the government's minimization procedures. They haven't been released.
Well, let me stop. And the minimization procedure specifically has the witness before was a little murky on this, specifically has a criminal justice exception. So running a criminal justice investigation with data that you now have can be done without articulable suspicion or probable cause or anything. You just go look to see, as the gentleman was suggesting, who's been committing gang crimes. You got a gang member, you can spin his little thing around to find out who he's talking to. Is there a limitation on what you can do after you've gotten it?
No, almost certainly not. And we know that the limitations are very weak because we've seen the 702 minimization procedures. Those were disclosed. And if they're any guide, I think it's safe to assume that the 215 procedures don't protect Americans' privacy.
Now, if you're running a criminal investigation without probable cause by virtue of getting information in the hands of the FBI, and we've removed that firewall that used to be there, what would be the sanction against improperly using that information? Would the exclusionary rule kick in?
Well, I don't think we'll ever know because the government doesn't notify criminal defendants that it's using these kinds of surveillance programs.
Would fruit of a poison tree kick in?
Well, it would if the government disclosed, but it doesn't disclose. It keeps it secret from criminal defendants. And this is one of the things that we've been very frustrated with, is that the government told the Supreme Court that criminal defendants would be notified when information was introduced against them derived from these programs. And it's not, in fact, giving that kind of notice.
Thank you. Mr. Chairman, it was a courtesy to my colleagues. I'll yield back at this time.
Thank the gentleman from Virginia. At this time, we yield to Mr. Johnson for 5 minutes.
Excuse me, Mr. Gohmert. This is regular order.
Yeah. Okay. Well, I was just going by the list that the clerk gave me.
The list goes from the beginning of the committee. I think Mr. Johnson knows. Thank you.
Exactly. All right. Then we'll yield 5 minutes to my friend from Texas, Ms. Jackson-Lee.
I thank you very much. Let me just say that this has been not eye-opening, but it raises more questions than probably it gives answers. And I think I want to start immediately with the question, Mr. Jaffer, on the 215 Patriot Act, which grants the FBI broad authority, as we've seen in the previous hearing and what we've read, and could put and does put civil liberties at risk. To your perspective, what danger might occur, or what would happen if we did not renew Section 215?
Well, I think that's a good question to ask the government. So far, they haven't been able to explain why the dragnet surveillance under this provision is actually necessary. They haven't been able to point to cases in which this particular surveillance program was crucial. I think it's a good question to put to them. But I would just say that while I think that your concern about 215 is totally justified, I think that the committee ought to be concerned about 702 as well. And the government keeps emphasizing that this is a program directed at people abroad, and that's true. But in the course of surveillance of people abroad, the government is building huge databases of Americans' phone calls, not just the metadata.
So you're saying that reverse targeting is occurring, even though language put in the bill to not have that occur?
I actually am not saying that the government's violating the statute. I'm saying that they're using the statute precisely as it was designed to be used. But the statute allows them to gather Americans' communications so long as they are not targeting a specific American.
So to hold them until they believe something rises to the top.
That's right.
So it's sort of like storing in your internet or storing pictures in your iPhone or something of the sort.
That's exactly right.
Let me go to Mr. Baker. You sat before the Homeland Security a number of years. Thank you for your service. Thank all of you for your service. But you made the point that on your blog that you thought that the FBI could have caught the people in 9/11, but there was too liberal civil liberties was too much in the way. What are you suggesting when the idea of 9/11 was, one, these were foreign nationals, so the FBI had opportunity to deal with them in the construct of our civil liberties, and it was basically connecting the dots of not finding out that guys were learning to take off and not land in a plane training place down in Florida. What civil liberties need to be violated in order to have protected us from 9/11?
The problem is that there were two al-Qaeda operatives in the country for 2 weeks. We knew, the FBI, the CIA, all knew they were here. But the FBI's task force that was organized for the Cole bombing, as I remember, was not allowed to go looking for them, even though they had by far the most resources of anybody to find them. And the reason they were not allowed to do it is because the FISA court had made up a doctrine that led to the wall that said, we're going to keep law enforcement over here and intelligence over here and not allow them to talk. And out of fear that the FISA court would punish them for talking and for going to look for these guys, the Cole task force stood down. We lost our best chance to catch those guys at that time, and it was because the FISA court was so aggressively enforcing a doctrine that, frankly, it shouldn't have adopted in the first place, but which it adopted pretty clearly for civil liberties reasons.
Well, let me ask your comment on that.
I think the record is much more complex, that there were many times that the government dropped the ball when it might have stopped 9/11, and most of them had absolutely nothing to do with the law. The CIA, for example, knew for many months that the names of the hijackers. They knew that they wanted to carry out an attack against the United States. They knew that they had gotten visas, and they didn't tell the FBI to go find those people inside the United States. And the wall had nothing to do with preventing the CIA from telling the FBI to go find known al-Qaeda terrorists in the United States. The record is just much more complicated than Mr. Baker is making it out.
Well, let me just finish. So let me just make this comment. Maybe I'll be short of the red light. One, I maintain that we have too many contractors, unknown and unbeknownst, and the intelligence community. Thank them for their service, but they need to rein in this rampant proliferation of contracts, even though the government tried to defend it, its satellites, it's this, and really have a profound staff that is here in the United States government. The last point is the FISA court can stand a lot of review. One, I think there should be something about the balance of Democratic appointed judges and Republican, but I also think the release of opinions should be something that we should be able to allow to the public and therefore find a way to rein in all of this. I yield back.
Thank you. We have 4.5 minutes, 4 minutes, 20 seconds left in the vote. So yield to the gentleman for such time.
Thank you, Mr. Chairman. Section 702, collecting foreign data, intelligence data, metadata, content of communications and so forth. Is that correct?
Not quite. 702 is surveillance directed at people outside the United States, but it's surveillance of Americans' communications with those people outside the United States.
Yes, and collection of the scope you don't disagree with. In other words, content, metadata.
That's right.
And minimalization procedures in place that perhaps may not be as stringent as they should. Perhaps I'm not saying that that's the case or not, but with respect to the data collected under 702 of Americans that are just incidentally caught up in foreign-to-foreign communications or a foreign target that is communicating with someone in the U.S. Who owns that data? Is it the person who initiates the call? Is it the person who accepts the call? Is it both? Or is it the provider, the service provider, who owns the data?
I think that Americans have a reasonable expectation of privacy in their international communications.
Have there been court cases specifically on that point?
Yes, on the content of communications, yes.
Yes. Okay. So now, I would submit that when you're talking about surveillance, when you look at the definition of the word surveillance, it includes keeping a close watch on people or things. And so you can surveil a thing, and that thing may not have a constitutional right, but a person certainly does. I think we should be prepared to distinguish between surveillance, what kind of surveillance we're talking about. That's a term that kind of gets everybody excited. That's about really all I have to say. Anybody got any comments about that? I'll yield back, Mr. Chairman.
Microphone has been yielded back, and at this time, this concludes today's hearings. Thanks to all of our witnesses for attending. We know it's been a long day for you, and we appreciate you bearing with it. It is an important subject. It's only our future, our security, and our privacy. So thank you, and we look forward to your comments that we anticipate receiving back in writing, things that you wished you had said or wanted to say, and to direct us to that. So thank you very much. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is now adjourned. Thank you.